And I'll be doing this training about Deeds 101, which is really to get you prepared to know how to do the transfer on death deed training, which is in 2 weeks. All right, so in this session, you're going to learn how to locate a deed within the Maryland land records, which you can easily do online, how deeds are structured, how to interpret common provisions, and how to apply these concepts to a few sample case scenarios. There'll be a few points in the training where I might ask you to look up a deed in the land records. So if you haven't already, hopefully you have a Maryland Land Records account so you can participate. So some of the things we're not going to talk about is we're not going to talk about trusts, LLCs, condos, or non-residential deeds. Part of that is that is not my expertise, and that's not what our clients need. And also the training is already too long, so there's just not enough time to cover everything. And just so you know, the limits of what you will know at the end, you do not know. At the end of this, you will not know everything you need to draft deeds, record deeds, use deeds in estate planning, which is a complicated topic, and you can't help somebody inherit a house. That all of those things require more information than you're going to get today. Okay, so why do you need to be able to find the deed and understand the deed? So it's going to be essential for knowing who owns the property and how do they own it. And that's going to be important in any area of law where you need to know what does this person own and what's going to happen in the event that somebody dies or whatever the case is. And real estate is going to be the bulk of many people's wealth, especially for low-income people who own a home. And so this is especially important in understanding their assets and their financial situation. There's going to be 3 parts to today's training. I'll go over just some basics of property law, and then I'll show you exactly how to find a deed in Maryland, and then how to read that deed so you know who owns it and what's going on. So first, we'll talk about what happens when a homeowner dies. And that's going to depend on a few things. So in the deed, it's going to tell you about how different people own property, and we'll go through the different types. But it's either the homeowner's share is either going to pass through the deed itself to a new living owner, or it's going to have to pass through probate to get to a living owner. So either the person dies and the ownership transfers automatically to the other person, or they die, it goes to their estate, and then through probate, it gets transferred from the estate to that person's heirs. And this difference is going to be pretty important, not just in terms of how many steps are involved, but for instance, if the property transfers through the deed, then you can't leave it to anybody in your will because it's not going to be owned by your estate. All right, so let's go a little bit more into goes through probate. So if it needs to go through probate, it's going to need to transfer from the estate to their heir. And there's going to be 2 procedural steps, right? One is probate, which we're not going to talk about. That's going down to the Register of Wills, filing all this paperwork, figuring who should be the next legal owner. And at the end of that process, you're going to need a new deed transferring the property to the heir. And it goes from the personal representative as the representative of the estate. All right. So when we're talking about how the property can transfer from a deceased homeowner to somebody else, there's two main types of ways that can happen through the deed. And one is through certain types of co-ownership, and the other one is through the life estate. And we'll talk about both. So there's three ways to co-own real estate in Maryland, right? A tenant in common, which means there's no right of survivorship. That person's share passes through probate. There's the joint tenant with the right of survivorship, and that's going to pass to any surviving owners when a homeowner dies. And the tenants by the entireties also has the right of survivorship, and so really is basically the same as the joint tenants, but it's only for a married couple, and it has some features that you don't need to know about for this training, but there are some other differences. All right, so yeah, if it's a tenant in common, one person dies, their share goes through probate to go to their heirs. And that's different than joint tenants, where the deceased person's share just goes to the surviving owner. And same thing with the tenants by the entireties. Just as a matter of law, the property interest has already passed to the other surviving owners. All right. So practice. So A and B own their home as tenants by the entireties, meaning they're a married couple. A dies, who owns the property? And then does this property need to go through probate? All right, so A and B own it as tenants by the entireties, but A dies, right? And because there's a right of survivorship, the ownership automatically passes to just B. So even though I'm getting ahead of myself. But B is legally the only owner of the property. All right, so a different problem. So A, B, and C own the property as tenants in common. A dies, but they leave their share of the property to B in their will. So what happens? Who owns the property, and does the property need to go through probate? All right, so A, B, and C own it as tenants in common, which means there's no right of survivorship. Then A, they're 1/3 of the property. Well, I'm assuming it's owned equally, but that's not necessarily the case with tenants in common. But all right, so A's share of the property has to go through probate to get to A's heirs, while B and C each still own their share of the property as tenants in common. All right, so the other way that ownership can pass through the deed is through a life estate. So in a life estate, the life tenant is the person who is owning the property now until they die. And at the point where they die, the ownership of the property automatically transfers to the remaindermen. So the remaindermen don't have rights to use the property while the life tenant is alive, but as soon as the life tenant dies, then the remaindermen are the owners of the property. And so when it transfers this way, it doesn't have to go through probate because it's transferring through the deed. And then just a note at the bottom. So if there are multiple remaindermen, they're going to hold the property either as tenants in common, joint tenants, or tenants by the entirety. And so you're going to want to note that. So here, yeah, so there's a life tenant and the remainderman, but as soon as the life tenant dies, then the remainderman becomes the new owner. And you might be wondering what's the difference between this life estate and the new transfer on death deed. They're going to be pretty similar with some differences, which you will learn about if you attend our July 30th training. A good bit of it will be about, what's the difference between what we already have and this new thing. All right, so A has a life estate on his home. B has the remainder. A dies. What happens? All right, so A is the life tenant, B is the remainderman. As soon as A dies, the property interest by operation of law passes to B. So B is the current owner of the property. Um, you see the raised hand? All right, so practice problem 6 is a little bit more complicated. So A has a life estate. A's 3 nephews are the remaindermen. Um, um, okay, and I should have said how they hold it. But let's say B, C, and D own it as own the remainder as joint tenants with the right of survivorship. And then A and C die. Who owns the property? And does the property need to go through probate? All right, so A was the life tenant, and these are the 3 joint tenants as remaindermen. So first, A dies, passing the property to B, C, and D as joint tenants. C also dies, leaving, so because it's joint tenants, their interest goes to the surviving owners. So just B and D own the property as joint tenants with the right of survivorship. And this is the same result whether C dies first or A dies first. Because even yeah, we'll talk about it in a minute. So what if the remainderman dies before the life tenant? Does their interest just go away, or does it go to them anyways? So yeah, if the remainderman dies first and then the life tenant's interest still passes to the remainderman, even though they're dead, right? So now it's owned by the remainderman's estate. And that's, of course, not what you intended, but it could nevertheless happen. So
Responsible. Take questions in the chat.
however you want to do it. Okay, all right. If you have any questions as we go, just put the questions in the chat and then we'll address them at the end of the training, just because there's so many people in the room. All right, so just at a high level, once a homeowner dies, there's really just 2 paths, right? Either the ownership passes through the deed, through the joint tenants with the right of survivorship, tenants by the entireties, or the life estate, and so it's passing to other living people, and so there's no need for probate. Alternatively, an owner dies, but their interest does not pass through the deed in one of these ways, right? And then, so their interest must pass through probate to their heirs. Okay, and then, okay, so like, we're going to talk about if the homeowners own it as tenants by the entireties, but then they get a divorce, what happens? So what should happen is they get divorced, there's a property settlement agreement, and then a new deed is signed, showing that the title to the property is being transferred just to one of the ex-spouses, assuming that one of them is keeping the home. But what's important is that you're going to have 2 different steps. First, the court has to decide on the divorce settlement agreement, and you get that court order. Then you also need a new deed. But sometimes that new deed is never drafted and recorded, especially if the parties weren't represented. And so that can be a problem. All right, so even if the parties agreed that only one spouse would own the property, if there was not a new deed recorded, then the title has not transferred to just that one spouse, that one ex-spouse. And so they owned it originally, most likely, as tenants by the entireties, but as soon as they got divorced, that right of survivorship was severed. And so now they actually own it as tenants in common. And so when the the other ex-spouse maybe dies, their half of the property has to pass through their estate, right? So half of the property has to go through probate, even though neither party understood it as being owned by them at all. And so you really want to make sure you get the new deed signed after a divorce. All right, so that's kind of the mechanics of how the property ownership could transfer. But now let's talk about how to find the deed. Um, Fortunately, it's very easy to find the deed in almost all cases. Um, and so, um, um, so, so you definitely need to find the deed, so you can know what's going on. Um, so first, you're going to go to the SDAT, Real Property Search. That's going to give you the book and the book and the page numbers to find the deed in the land records. And then you'll go to a second website, Maryland Land Records, and enter those deed reference numbers to find the deed. And I'll show you how to do that. Okay, so the first website is the SDAT Real Property Search. You can just Google that and you'll get it. It's just going to ask you which county it's in. And then you can select street address for how to search. You're going to enter the street number and then the street name. And don't put north, south, or avenue or anything on the second line. Sometimes that's going to give you just two different options. Like if the address had like north or south in it, then it'll give you the north and south options to pick from. That brings you to this screen. And it's going to tell you on the left side, it's going to tell you who SDAT thinks is the owner of the property. That could be helpful, but as an attorney or paralegal, that's not what you're going to go by. You really need to look at the deed to know what's going on. And so almost all the time, there's going to be these two numbers next to deed reference. The first is the book. It's also called the liber. And the second number is the page, also called the folio. And we're going to need those numbers to look up the deed. All right, so then to go to the second website, Maryland Land Records, you're going to need an account, but it's free. And then once you select the right county, then it'll ask you for the book and the page number. And so we'll enter the book and the page number that we found on the SDAT page. But if it gives you some zeros in front, just don't enter those or it'll give you an error. And then hit go. The book and the page number are a lot of times correspond to actually multiple places in the deed records, but it's usually just four. And so you might need to just guess and check between them, or if you know what year you're looking for, or approximately, then you can just select that one. And then you'll find, until you find the deed. And this is just a photocopy of the deed and the deed record, so you can really read it for yourself, which is what you're going to need to do to really know what the ownership is. All right, so if you have a land records account, I want you to try to look up 503 South Belnord Avenue in Baltimore City. Just to practice looking up the deed, first you're going to go to that SDAT website to get the deed reference numbers, and then go to the Maryland Land Records website. We won't worry about reading the deed yet, but just to make sure you know how to find the deed. And I'll just give you 1 minute to do that. All right, so you should have looked it up, and this is what you should find as the most recent deed for the address. So the book number should have been 27492, and the page is 317. And they should have found a deed from October 16th, 2024, with these people. All right, so that I would say that's the standard way to find the most recent deed. But you're always going to want to check through these other two methods, just to check your work and make sure there's not another deed that you're missing somehow. So first, there's a way in Maryland land records to search by address. I think just if you're in Baltimore City, or search by owner name. So you should know who you think is the owner, and to see what's going on. But those only show things that were recorded since about 1970. So it's not going to show you something that's very old, but it's going to show you if there's anything that was recorded since then. And then also talk to the client, just to make sure that what you found matches up what the client thinks is the situation. The clients don't always know everything about their deed. That's fine, but they might give you a clue that you're missing something. So the reason why you're going to want to search through these other ways is that the new transfer on death deed is likely not going to be found on the SDAT page, but it will be findable if you search by owner name or address. And so you're going to want to know if that's been recorded, because that could change how you counsel the client, or if the person has already died, then it could change who is the legal owner of this property. And then you're also going to want to check, because there just could be a mistake in the SDAT information. Like maybe there was a new deed recorded, but for some reason it didn't get indexed properly. And so there's a more recent deed that's changing what's going on. Sometimes there's not even going to be any deed reference numbers written there at all. Particularly, that means that there haven't been any deeds recorded since about 1970. And so they just don't have that information indexed. So what do you do if you can't find this? So it's going to be harder than just looking it up through the other way. Still, you're going to look through land records by address or owner name, and that's going to give you a list of what has been recorded since 1970. If there's a mortgage that was taken out since then, that will reference the deed. And so if you're reading it through it, then you can find the LIBOR and the folio of the most recent deed. Or if there's a release or a refinance, those will reference the LIBOR and the folio for the mortgage, which then in turn could reference the LIBOR and the folio for the most recent deed. And again, you can ask the client. They may have a copy of the deed, or they might have more information for you. And then lastly, the land records office may be able to find it, because they may have access to just more of the land records database than you. All right.
I'm just going to jump in quickly to address some questions in the chat. Some people had trouble using the search and were asking if we could show it. We do have a lot more content to move through, so we're not going to switch into that now, but we're going to hang out for a bit afterwards to address questions. So if we have time, we can maybe pull up the site to do a demo after the training's completed.
Yeah, and yeah, I'll show my screen working through the next example if we get to it. All right, so once you have the deed, how do you read it? Okay, so who are the owners? So typically that's going to be who the most recent grantees are in the deed, because a deed is always phrased as giving ownership from one party to the second party. And so whoever is receiving it the most recent time, usually that's going to be the current owners. That could not be true in a life estate deed, um, or um, or if not all of the property was transferred in the most recent deed. Um, but generally, this is going to be your owners, or at least your owners of record, right? If one of these persons had died, then the ownership is going to transfer in the way that we talked about in the first part. All right, so if there's multiple owners, multiple co-owners, how do you determine how they hold it? Is it tenants in common, joint tenants, or tenants by the entireties? So it's going to say it in the deed explicitly, oftentimes, and then we'll talk about it if they don't say it. But you're going to be looking to two parts of the deed. The first part is the granting clause. It usually starts with like witnesses, and then it's going to say the party of the first part gives it to the party of the second part, and in this case, as tenants by the entireties. Right. So now we don't need to guess as what type of co-ownership they have. It just tells you. The second part where it's going to talk about the type of ownership is in the to have and to hold clause. Again, it says as tenants by the entireties. So you just want to check both parts to see what it says. And the to have and to hold clause is probably on the second page of the deed, which you have to hit next on the right side in order to see the next page. So what if the type of co-ownership is not explicitly stated? Then generally the rule is that they own it as tenants in common. But if the co-owners are married to each other, then the presumption is tenants by the entirety. All right, so what if you have two people that are not validly married to each other, but the deed says that they own it as tenants by the entireties? Does that make it tenants in common, or does it make it joint tenants? So it makes it joint tenants, and this makes sense because they're by saying that it's tenants by the entirety or presenting themselves as husband and wife or as married, then they're signaling an intent to have a right of survivorship. And so the rule is that even if the marriage is not valid, the right of survivorship is still there. Another rule that you're not going to see that often, but it's going to come up, is what if it says that the people receiving it are a married couple and a third person, but then it doesn't tell you what type of co-ownership they have. How do they own it? Do they all own it with a right of survivorship, or what's going on? So the common law rule is that the married couple, are going to own half of it as tenants by the entireties, and then the other third person owns half of it as tenants in common. Of course, if you just state explicitly they all own it as tenants in common, or that they all own it as joint tenants, then it's going to be that. But just if it says it's owned by these three people without telling you what type of co-ownership, then this is the default rule. All right, so if it's a life estate, that's usually going to be the hardest to decipher, because there's different ways to say it, and there's a lot of more language to read to figure out what's going on. So you're still going to look at this granting clause and the to have and to hold clause to figure out what type of ownership there is. Sometimes a life estate deed is going to be phrased as conveying the property like to yourself, subject, or conveying the property to yourself, but a remainder to the other person. And so then at the beginning it'll say party one is the person's name, and then party two is also the same person's name. But when you read these other later paragraphs, it says subject to that it'll go to this other person once this grantor dies. It could also be phrased as giving away the whole property, but reserving a life estate. And then if there are multiple remainder men, you just want to also determine what type of co-ownership do they have. When you read the deed, it's going to give it, party of the first part gives it to party of the second part. Their heirs and other things. That doesn't mean that it's not granting it to their heirs. What that's really talking about is that the party of the second part also has the power to leave it to their heirs when they die. But the party of the second part is just who's listed. There's no, the heirs aren't getting any power or contingent benefit or anything. So really you just want to ignore that. All right. So, all right, we're going to do this practice problem where you're going to look up the deed and decide who owns the property. So this potential client calls you. His name is Lewis. Lewis Sr. and Rose, the potential client's parents, have both passed away. And the potential client is saying they are on the deed. The address is 1615 North Payson Street in Baltimore City. And you're trying to determine who owns the property, and does the property need to go through probate. So I'll give you about a minute to try it, and then I'll walk us through it. And hopefully you've given that a try. So I'll walk us through this. All right, so first we'll go to the SDAT website. All right, so first we'll go to the SDAT website. The problem set is in Baltimore City. Street address. Continue. 1615 North Payson Street, but we don't put the north in. So I see this information. I want, so 1804 is the book number. And then 298 is the page number. Right. So we're gonna ignore any zeros that are at the front. That'll cause us trouble. All right, so then we go to the manual land records website. I'm already logged in. We go to Baltimore City. That's where we are. All right, so the book number was 1804, and then the page 298. And then in the problem, it didn't tell us what year it's from, so we can just guess and check these ones. And then when I'm looking at the grantees, it says Lewis P. Butler Sr., Rose Butler, and Lewis Butler Jr. So this is probably the right deed, but then we can also look at the property description. It says known as 1615 North Payson Street. All right, so we're looking at the right deed. And then the problem said that the problem said that Lewis Sr. and Rose have passed away. And then so trying to figure out who owns the property. So if Lewis Sr. and Rose passed away and Lewis Jr. is still alive, then who owns it? So we need to think about what type of co-ownership did these three have? Okay, so it says in this witnesses part, it says grantees as joint tenants and not as tenants in common. And then we'll just check the next page just to make sure it looks the same. All right, so then we find this to have a to hold clause says to the grantees as joint tenants and not as tenants in common. All right, so it looks like those three, Lewis Sr., Rose, and Lewis Jr., all owned it as joint tenants. So when Rose and Lewis Sr. passed away, then Lewis Butler Jr., through the deed, became the owner of the whole property because he's the only surviving joint tenant. So this person that's calling, he's like, well, do I need to go to probate or what needs to happen? And legally, nothing needs to happen because he is the only owner with no need to go through probate. And I walked through this on here. So, all right. So other parts of the deed that you're going to want to look at. So in the deed, anytime it says like whereas, this is information that the drafter is trying to tell you so that you can better understand how this person came to own the property, typically, because when you're looking at the deed, there may be information that's helpful to know, but it's not in the legally operative parts of this deed, and it's not in the prior deed. So, for example, if it says, whereas A and B owned the property as tenants by the entireties, but A died on or around this date, and then so just to explain, A's ownership was transferred to B by operation of law. So B has title to the property in fee simple. So this is helpful when you're tracing who owns it because it tells you on or around this date, this such and such person died. So if you needed to verify that information, you have what you need. And it's explaining why in the most current deed, maybe B alone is transferring the property to someone else. You might wonder, well, where did A go? But the whereas clause is there to help you understand how we got here. All right, the next section that's important to know about is the legal description. So that's telling you what property exactly is being transferred. There's two basic types of how to describe it. One is if there's a plat. The plat is like like a bigger section of land has all been divided up, and each lot has been numbered accordingly, and those plats are all located in the land record somewhere else. And so then you can just say, I'm transferring lot 96 and 97 on such and such a lot. And so that's going to be very short and easy to understand. The other type is called meets and bounds. And so that one's going to be a lot harder to follow because it's going to tell you at such and such intersection, you go 200 feet in such and such a direction, and then it's going to encompass a certain place Usually you're not gonna try to figure out exactly what that means, but you definitely want to at least verify that the address that's listed at the bottom is the property that you're worried about. All right. So the being clause is going to tell you what was the prior deed in the chain of title. So it's usually going to tell you a date, either when it was recorded or dated, who were the prior owners, and then which county it's recorded in, and then the library and the folio of that prior deed, which you may need to look up to really understand what the property situation is. Usually you don't look back at the prior deed if it seems like everything's self-explanatory, but it could be that only one of the owners transferred their 1/3 interest to somebody else, in which case you don't know who owns the other 2/3 unless you go back in time a little bit to the prior deed to see who owns the other 2/3. And then if you need to list or just cite another deed, then you could use like a further being or being also, and you're just trying to also identify the property according to some other deed so you can explain kind of where all the ownership is going. All right. One of the last things we'll talk about is ground rent. So in Baltimore City, lots of properties have ground rent, which is an annual or semi-annual payment. It's going to be around $100, somewhere between $50 and $200. And it's usually just annoying. But non-payment can cause catastrophic loss. So if you don't pay your $100 or so, you could end up with fees to this ground rent holder of could be around $2,000 over an unpaid bill of $100. And if you don't now pay this $100 and the $2,000, then you're going to lose your house and get none of the equity back. And this overwhelmingly affects Black communities and low-income households, particularly in Baltimore City. So if any of you are in charge of the world, you can get rid of this at any time. All right, so when it comes to the deed, what do you need to know? So first you need to know, do you have ground rent? So in the deed, if it mentions a leasehold interest, then that's going to tell you that there's ground rent. On the SDAT website, it's also going to have a place at the top of the page. It'll say ground rent registration on file. So that means that somebody has registered a document saying that there is in fact ground rent. You can also look at the prior deed, and it will mention ground rent in the to have and to hold clause. And then definitely ask your client, because even if you have these things before that are indicating that there may be ground rent, the client may have actually bought the ground rent and just never that ground rent redemption was just not indexed, or they didn't report it to the SDT people. And your client's definitely going to know if they're cutting a check twice a year. That's either happening or it's not. All right, so in the deed, it's not going to talk about fee simple because you don't own it fee simple. You actually only own the leasehold interest. You're really treated as a renter of the land that you've built the house on. Yeah, you're going to look in the to have and to hold clause, and it's going to talk about that somebody's just getting this property for the lease, basically, subject to this payment. So as we wrap up, yeah, you don't have the power or you don't have the knowledge at this point to draft the deed, but just so you know, we, MVLS, we help lower income people for free only because we have volunteers who help us. And at this point, right now, you can go on our website, the mvlslaw.org/pro bono portal. And we have 3 people asking for help redeeming their ground rent, and 5 people asking for help writing a new deed to help with estate planning. And with that, that is the end of my presentation. Thank you.
Okay, so we'll start addressing some of the questions that have come up. And if you've heard the echo, Stephen and I are in the same room, so there may be a pause as we mute and unmute to address your questions. I'll start by handling a couple that just came in. Stephen, when you were talking about ground rent, one of the questions is, would it be cheaper to buy the land? In terms of whether or not it's more expensive or not to continue to pay the ground rent or to buy it out, or what's called redeem it. It really depends on how long a homeowner lives in the home or owns the property. There is a formula built into state law for the cost to redeem the property. Typically, the annual payments, they range, but they're fairly low. Maybe $90 to $120 is typical per year. And to redeem it, it might be around $1,500 to $2,000. So the decision to purchase it or not, and whether it's right for somebody, is an individual decision. Not everybody may be able to afford to do so. But for people who can afford to get rid of it, it does reduce their vulnerability, because they don't have to worry about remembering to make those payments. Somebody else asked if ground rent is only in Baltimore City or if it's in other counties. It's not specific to Baltimore City. It does exist other places as well. But we do see it more often in certain neighborhoods in Baltimore City. And I'll take one more question before kicking some over to Stephen. Another question that came in towards the end was, how do you know how many pages the deed is? So when you look up a deed in land records using the book and page number, it just brings you to the first page. And then you can, on the right side of the screen, click next to continue to scroll through those pages. Deeds vary in length. Some are 1 or 2 pages. Ground rent deeds, transferring ground rent for the ground lease for many properties can be really long. So you only really know by kind of scrolling through it. But once you've identified, let's say it's 3 pages, you can then put in the number of the first page and the last page for the system to generate a PDF that you could download that has all of the pages of the document. You don't have to download them one at a time. Is ground rent still legal in Maryland? It is. There was an effort at one point to get rid of it. And there was I don't remember the name of the case, but there is a Maryland case saying we can't just get rid of it without denying property owners their rights. So there are statutes, protecting the rights of individuals who own property subject to ground rent, and mandating a process through which somebody can redeem. So the person who holds the ground lease cannot refuse to allow someone to redeem the property. We're not going to go into great depth on that since that's not the focus of today's training. But if you're interested, if you're an attorney who wants to volunteer to take those cases, our team would provide support, as you get up to speed in that area. So now I'm going to kick some questions back to Stephen that came up earlier in the training. So Stephen, I'm just going to read a couple of them to you, and then I'm going to go on mute. The first 2 questions relate back to when you were talking about the forms of ownership. So the first question was, if 2 people own property as tenants in common, but they later get married, what form of ownership do they have after they're married? Does it remain tenants in common, or does it automatically change to tenants by the entirety? And the second question was, in your example where there's a life estate and the remainderman predeceases the life tenant. Let's say there were 2 remaindermen and one of them had a will. the one who predeceased had a will, what happens with that person's share? Does it pass through their will, or does the other remainderment automatically own it? So I'm gonna go on mute.
Okay, so the second question was, yeah, what if the one of the remaindermen predeceases, then does it just automatically go to the remaining surviving remaindermen, or does it go to their estate? So it depends on what type of co-ownership they had between the two remaindermen. If they owned it with the right of survivorship, then the interest that was going to go to the deceased remainderman goes to the surviving remainderman because they owned it as joint tenants or tenants by the entireties. But if the remainderman owned it as tenants in common, then the deceased remainderman, their share, once it passes to their estate, would go to their heirs through probate. The first question was about if two people own property together, but then they get married. I guess I would want to do some research to double check, but I would say that it stays tenants in common. Yeah.
Okay, I'm gonna take a couple more that came in. So one of the questions is, will there be a fee imposed for the future, in the future, for use of Maryland land records? We don't know. There was an effort recently, which we strongly opposed. The Maryland State Bar Association and other legal services organizations also strongly opposed, which fortunately kept that at bay for a bit. But it's hard to know if in the future there will be a charge for accessing public records through Maryland land records. Obviously, for now, you're able to do that for free. If in the future it comes up again, we would love broad support in fighting against that because the ability to access these records for free is important for being able to serve folks who are low income. And we think everybody should be able to access their deed for free. But let's see.
Okay, so just taking some off the chat. So yeah, a deed and a deed of trust. A deed of trust is basically a mortgage. Um, can a property have a mortgage and ground rent? Yes. But the ground rent is really independent of the mortgage. The ground rent is a system that has existed for centuries and really shouldn't exist.
Another question that came up earlier in the session, somebody asked if you have to be on the mortgage to be on the deed to the property, and you do not. Those are two different things. It's not uncommon, for example, for a married couple, if one person has better credit, maybe the mortgage is in one person's name, but the deed can still be in both individuals' names. And usually if there's a mortgage on the property, someone can still add somebody to their deed, but if someone's on a mortgage or a loan secured by the property, you have to be really careful removing that person from the deed because it could trigger the loan to be due immediately. So if you're ever looking at a deed change and you're not sure how it might impact an existing loan, you want to be sure that you're getting counsel from an experienced attorney. I also saw there's a question about if somebody wants to volunteer for one of our cases, would they receive supervision? Yes. So just as a general process, when folks want to volunteer with us, we don't automatically, like co-counsel cases or require supervision. But we do want to make sure we're providing really high quality services to our clients. And so when we have volunteers come into a newer area of practice or they encounter a new issue, the reason that we have staff attorneys is to be able to provide that support. So, we do have volunteers who are taking deed cases who don't have a great deal of experience or maybe practice in a different area in their day job, and so they don't have a colleague who they're going to for support, and they may ask us questions, sometimes send us drafts to review. We provide feedback and support in addition to the trainings such as this one. So if you have any questions about that, please reach out to us afterwards, and we're happy to help answer any questions about that process.
There was a question about what's an enrolled agent, because they're one of the people who can volunteer with us. An enrolled agent is a tax professional. So if you're not a lawyer or a CPA, then you can't, or an enrolled agent, you can't take a case by yourself. So if you wanted to volunteer with us, we'd have to find a role where you can work under an attorney. So especially if you work with lawyers, and maybe you could convince one of them to take a case and let you assist, then that could be appropriate. But only lawyers and these other professionals can take a case by themselves.
So we are at 1 o'clock. Several people asked about whether you would receive the slides or recording. Our plan after this training is to send to everybody who registered for the training a copy of the recording as well as the slides. Might take a couple days to get out because we'll, clean it up with some editing, but that will be coming out. And if you have any questions, feel free to follow up. I will also include in that email a link to our training on July 30th for transfer on death deeds. I imagine many of you saw that announcement at the same time as the announcement for this training. But in that session, we will be reviewing what is the transfer on death deed, how is it different from the life estate deed, and that the target audience for that session is legal professionals, so we won't be showing a homeowner, for example, how to complete that, because the goal is to answer the questions of folks in the legal community as we prepare to support the implementation of that deed. So this will kind of formally end today's training. We will hang out for a few minutes in case people have additional questions. Thank you. So I see there's a comment in the chat about a soft second. We're not sure what you mean by that. So if you want to add some clarity, we can hopefully answer your question. So there's a question about what is the additional training. So like I said, I'll include a registration link when we send the follow-up email. But on July 30th, we have a 2-hour session called Transfer on Death Deed Overview for Legal Professionals. So the transfer on death deed is a new type of deed that was authorized in this year's legislative session. It becomes effective on October 1st, and it functions similarly to a life estate deed, but it is a product designed for homeowners who cannot access legal services and are trying to make a deed change for the purposes of estate planning without the help of an attorney. So when the legislation passed, it had a statutory form for the deed, as well as some other accompanying forms. So we'll talk through what was the purpose of the legislation? How does it function? What are the different forms? How can they be used? And considerations that legal professionals need to keep in mind when they're, considering whether to use this new type of deed or the traditional life estate deed, as well as just providing some consistent information to folks across the state so that as we engage in education with community members, we're providing consistent and accurate information.
Okay, there's a question about ground rent. It says I found a deed that has ground rent listed on STAT, but they're not sure if the ground rent holder is still in business. So in the law, if the ground rent holder does not request payment for 20 years, then the ground rent stops existing. So if nobody's asking you for payment, then don't pay them. And if they do ask you for payment, then you can ask for proof that they're actually entitled to it. If the person listed as the ground rent holder has gone out of business. There's also an option to redeem the ground rent through STAT if you can't get a hold of the ground rent holder. So if you're just looking for clarity and you're like, I just want to get this straightened out, I don't care, then you could redeem it through STAT. But yeah, but if you're comfortable just leaving it kind of open, then I would just not pay it if nobody's asking you to.
So we're reading your comment, Dorothea Parker. I think it's possible this may be outside of the scope of situations we're accustomed to dealing with. So I don't know that we have an answer for you. Just in general, sometimes, Stephen walked through the way to find a deed when they're easy. Sometimes it does take a lot more digging to find a record. So like he highlighted at the end, SDAT is often a good starting point. But sometimes things aren't indexed there. At times, if I'm struggling to find a document that I believe exists or know exists or suspect there's something I'm not finding easily, you do want to go through multiple search records, including trying different versions of someone's name, address. Like Stephen said, sometimes there's a recorded document that references another document, and you can look through things that way. There are block books. This is getting more in depth than like a 101 training. But there are kind of additional search techniques to use for more difficult searches. Most of the time, a name or address search in land records is able to produce what people know exists. But just practically, when we're working with clients, we ask them, when's the last time you think the deed changed? To get a sense of what's the time frame for something that they know exists. And if we find something outside of that, then of course we look into it. But if they think something changed in 1990 and we're not seeing it, it's a key for us to, keep digging and looking a little harder. I see there was another question around statute of limitations for ground rent if it's not been requested. So if you look in the Maryland Code, like I said, there are a lot of protections for people who are subject to ground rent. So if somebody hasn't been sending bills, but they are entitled to ground rent, once they send a bill, they're limited to asking for payment for the last 3 years. So someone couldn't sit on their rights for 20 years and then 19 years and then come say to you, okay, you owe us money for the last 19 years. There is a limit. So oftentimes when we're working with low-income homeowners, when we see that they have the reference to ground rent in their deed, it was never redeemed. If we ask them, is anybody sending you bills and they say no, then what we counsel them on essentially is they don't have to do anything. They don't need to seek out this person to try to pay them. It's the responsibility of the person who owns the ground to send those bills if they want to get paid. And they also have to register that with the state. So in a situation where someone is subject to ground rent, but they are not actively receiving bills or the ground rent holder never registered it, we will generally advise that homeowner on their rights, but counsel them, if you ever do receive a bill, don't just ignore it. Take the steps necessary to see, has this person done what they need to do to be authorized to send you this bill? Do you actually need to pay them? So, use your due diligence, avoid a scam, but don't just ignore it because it could be something that legally they have to pay. And again, if people have questions about whether or not those bills are legitimate, they could reach out to us for support with addressing their ground rent because that is an area of law where we assist. There's another question about the process to take an MVLS case. So if you've never taken a case with us, there is a sign-up mechanism. You can initiate it from the website. I'll also drop my email in the chat. People can, if you're interested in learning more, feel free to email directly afterwards. But it's a fairly straightforward process, but we do have a process for first signing up volunteers, making sure that our volunteers are legal professionals, appropriately barred, etc., before connecting you with clients. So the first step would be to sign up with us, and then you can sign up for specific cases. I just mentioned being appropriately barred. There is a rule that permits individuals who are barred in other jurisdictions to take pro bono cases. So if you're barred, for example, in DC, but you want to take a case here, there is a process for getting you set up to do that. And we have a volunteer coordinator who can provide support to volunteers as you're going through that process. So I think at this point, we'll wrap up. I don't see any unanswered questions. Like I said, we're going to follow up with a copy of the recording, the slides, and a link to register for our session on transfer on death deeds. The other thing I will preview is that we are planning to do a training on recording deeds as well later this summer. So we have not, I don't think we've released the sign up for that yet, but stay tuned if you're interested in additional trainings related to deeds and deed changes. Thank you.